Any mention? Item number 1. Excuse me, my lordship, I like to mention item number 30.
Item number?
30. I'm for respondent number 6, Sujata Das. No, my lordship.
What is your name?
I beg to mention.
Who's your senior?
S.A. Sheikh.
This is single bench.
Oh.
This is DB.
I like to mention.
Please explain to her. It's the first time you're mentioning?
Yes.
Yes. Someone please explain to her. Explain to her. Yes.
Number 1. But I have instruction to withdraw this appealment.
So Mr. Ghosh has come all the way.
Yes, my lord.
Because that memorandum will operate, I think, regarding now it's raised to 2 crores with regard to the hearing of appeal.
They've taken a decision considering all the factors, my lord. They don't withdraw. Mainly on that ground level.
Can we have a copy?
Then we will record it then. Today when the matter is taken up, Dr. N. Mozika, learned DSGI with so-and-so, submits that the department does not wish to pursue the appeal and prays that be allowed to withdraw the same. Stop a copy of the communication dated 18/3/2025. Has also been placed before the court. Stop. Mr. Ghosh is present on behalf next time of the respondents. The prayer for the withdrawal next paragraph is allowed. Matter stands closed and was disposed of for calling.
Okay.
Item number 2.
Internal communication.
My lord, may you have a copy of the communication? So communicate.
Yes, a copy of information be also supplied to the General Counsel for the
So
respondent.
yeah, he is telling that since it is internal communication, it cannot be.
Yes, the privileged communication given to the council, but as a concession.
Great for me.
Oh, let's do it.
My lordship, I'm appearing for respondent number 8.
Number 8, then you take down the names. Yes, 8.
I think she's making mention for the next item.
Next item.
You're totally confused. What is your name?
V. Karnong Long.
You better, before you appear in court, in the High Court, you better take proper instructions from your senior as what matter you're appearing. No, please listen. I don't want to raise my voice as a junior appearing first time. You please take proper instructions from your senior as how you address the court. They are the appellants. Now, who submit first? When you have to mention? How long you practice?
It's just 1 year, your lordship.
This is the first time in the High Court. Where's Mr. Sheikh's other colleagues?
He's out of station.
No, where's the other? Who's that? Mr. Amarak? Where is he?
He's also out of station.
There's some standard in the practice in the High Court. How you mention when the matter is called out. Mr. Sheikh, tell him to meet me in my chamber tomorrow when he comes. Yes.
So I think he's appearing in this matter, item number 2, for respondent number 8.
Yes.
I think they informed me they'll again take an adjournment, my lords. My lords, I had filed an application. No, it's not. Condemnation is later. I had filed an application craving leave to be made a party in the. I'm a non-party, my lord.
Yes. Any objection? No. How are you affected?
So I'm the managing committee. I'm representing the managing committee.
You were
the
not
writ
there
petition I was not made a party because my lords, at that time the represent my lord, the impugned order
The order you seek impugn rather?
Yes, my lord. Did I do it? At page 18, 1/8, my lord. Order dated 31st of July 2024.
Yes. Page 18.
1/8, my lord. An extra one. Lordship will see from the array of parties, the managing committee was not a party in this
That's what
case.
is.
And certain observations have been made in the judgment, my lord,
Where is
which please see the observation at page 32. Page 32, para 38. I just read, my lord. Again, the relevant authorities have failed to note that the petitioner was appointed as head teacher on the basis of an advertisement floated in
Where are
this
you reading
regard.
from? Para 32.
Page 32, para 38.
Oh, sorry, yes. Yes.
Again, the relevant authorities have failed to note that the petitioner was appointed as head teacher on the basis of an advertisement floated in this regard. As this is not correct. There is no advertisement that was floated. There were no pleadings anywhere. Next, my lord, it is also observed that there was no challenge to the said selection process at the relevant point of time. Therefore, rightly or wrongly, the petitioner would be deemed to have been regularly appointed as head teacher in the year 2001. We are agreed with this finding as well, my lord.
Okay. Yeah, because it's not be floated by the managing committee.
Lordship.
Yes. Any other submissions?
My lord, we have no
You're appearing
objection.
for respondent number 8.
State has no objections.
And MS Mesokarma? You have no objections? Yes. And MS Shyam?
I'm assisting the
Assisting whom?
I'm for the state, my lords.
Oh, assisting, unless you're senior counsel. Yes. Yes. How is that done? That's not permitted. That's not permitted. You have heard Mr. S.N. in the miscase number?
Miscase 41.
41 2024. Yes, you look 2024. Yes. There's also Mr. K.P. Parachari appearing for the respondents number
1 to 5.
1 to 6.
126.
1 to 6.
Then MS B. Goswami for number 7 and so for number 8. Stop. This application has been filed seeking leave of this court to file a writ appeal, to prefer a writ appeal against an impugned judgment order dated 31/7/2024, passed in WC number 390 of 2016. Stop. The next part, the Learned Counsel submits. Learned Counsel for the applicant submits that the applicant desires to prefer the appeal in as much as in the impugned order, as much in the writ proceedings they were not impleaded as parties, and further in the impugned order certain observations have been recorded which were not in the pleadings, which has affected the rights of the applicant. Stop. Learned Counsel also taken the court to the impugned judgment wherein the observations are contained at para 32 of the judgment thereof. Stop. The counsel for the respondents have no objection to the said prayer of the applicant for leave to appeal. Stop. Next paragraph. On hearing the counsel of the parties and on perusing the impugned order sought to be appealed again. Stop. This court allows the instant application and the applicant is permitted to file a said appeal. So, in this case, what he stands disposed of.
Obliged, my lord.
Item number 3.
Doesn't matter. It's not important to appear.
We'll come up next.
Let's-
Lordship.
Yes. Yes, yes.
Your Lordship, this case is listed for condemnation of delay. There is a delay of 101 days, Your Lordship, in filing this writ appeal. 2 and 3 are connected, similar matters, Your
2
Lordship.
and 3 are?
Connected, Your Lordship.
Now, you have filed for condemnation how many days?
101, Your Lordship.
Have they filed objection to condemnation?
I was informed that Sheikh will be filing objection.
Have they filed or not?
No, Your Lordship.
So you do have no objection to the condemnation?
My lordship, let my senior come.
Yes?
We are yet to file the wakalat.
Do you have any objection to the condemnation application filed by the appellant? They have objection or not? What's the last order? They're throwing this poor lady into the deep end. Yes. There's no thing. See, there's no question, there's no objection to file. There's no said, even no when the order is recorded. See. Yes, this will be listed after 1 week, 2 weeks.
Your Lordship.
Okay, due to the absence of Mr. S.C. Sheikh, and as the junior counsel is not instructed in the matter, list it after 2 weeks. Yes.
Much obliged, Your Lordship.
Hearing item number 4.
But 4, 6 and 7 are connected matters. Mr. Saraf is in number 6 and 7.
My lord, in these cases, my lord, miscase has been filed. In the next case, my lord, miscase has been filed because this Mega Technical and Engineering Private Limited, my lord, this has been merged, amalgamated with another company that is Star Cement Limited, my lord. So one miscase has been filed
By whom?
by this Mega Technical.
Petition, Your Lordship, item number 6 and 7. Your Lordship, after filing of the writ petition, the petitioner company has been amalgamated and consolidated into Star Cement Meghalaya Limited. As such, we have filed 2 miscases for amending the writ petition, Your Lordship. Item number 6 and 7.
Where's the miscase? Miscase.
Item number 6 and 7. Your Lordship. WPC.
Do you have copy? Copy is there? To come. Dekha.
Okay. It's first time it's come up today.
Yes, my
Yes, Your
lord.
Lordship.
Okay. In item number 6. When was it amalgamated?
My lord,
The order is dated 10/5/2024. Your Lordship will find it at page number 13 of the.
But then why you took so long to file the application then?
Your Lordship, I apologize for that. We were informed a little late, Your Lordship.
What is that page?
Page 13, Your Lordship.
Annexure 1.
NCLT order.
Yes. Scheme amalgamation data Yes. We'll allow Dr. Mozika. This MS case number 44/2025. This in WPC number 59/2024. Stop. This application has been filed by the petitioner seeking amendment of the writ petition on the ground that the petitioner Mega Technical and Engineers Private Limited.
Yes.
Yes, Your Lordship. Engineering.
Yes. Have been amalgamated with Star Cement Meghalaya Limited.
Yes.
Yes, Your Lordship.
Yes, and the same ordered by ordered by the NCLT Gotti branch by order dated 10/5/2024 under the scheme of amalgamation. Correct.
Yes, sir.
Stop. Accordingly, next paragraph. The application stands allowed, and the petitioner is to make necessary amendments within
2 weeks, Your Lordship.
within 2 weeks. Yes.
Lordship,
Order.
item
Yes.
number 7, similar order, Your Lordship.
Yes. Similar order. And then the other item
Number 4
5.
come together.
Yes, this together with this so and so next date. Yes. After 2 weeks.
Obliged.
Item number 5.
But number 4 is interim order till today, my lord.
Interim order.
Wait, please, my lords. Lordship, I'm seeking for some accommodation today, Lordship.
End of the board.
Lordship,
You're already at the end of the board, I think.
no, Lordship, for next week, Lordship.
What's the matter about?
Lordship, this is a writ appeal. It's based on their retired deficit teachers, school teachers, Lordship. Their main grievance is non-availability of the pensionary benefits.
Yes, Mr. Shlai.
Lordship, their claim is they are deficit, a retired deficit teacher, Your Lordship. They claim pensionary benefit that has been turned down by the learned single judge. So against that,
After 2 weeks,
Lordship.
Highly obliged, Lordships.
let us counsel for the appellant due to unavailability of the arguments in a counsel. This is matter after 2 weeks.
Offline.
Any mention?
Lordship, my lord, I beg to make a mention of item 31, my lord.
Why?
31. Lord, the senior counsel is unwell, my lord. The senior counsel is unwell, my lord.
He's unwell. You argue it. What is this? A contempt matter?
I do not have the
ready in the matter.
I do not have the brief with me, my lord.
You can take the court's copy, no problem.
My like kindly grant some time.
Yes, after 2 weeks.
All right.
Yes. Yes.
Lordship, this item number 29. Where is 32? 29.
Yes.
29.
Item 29, Your Lordship.
Yes.
I am engaged today only, and I have submitted my power.
Whoever these
because
young lawyers
Mr.
appearing this
K.N.
matter.
Chaudhary, he has been. I understand yours. I was told like this. Mr. K.N. Chaudhary. Mr. K.N. Chaudhary has withdrawn himself. Now they.
Where's the counsel from Guwahati who was come and mention?
No,
Mr. Mehdi was there.
Where is he?
He's not coming.
He's online?
No, he's not there also.
because he has given us the wakalatnama. Maybe whether he is appearing or not, I am not sure.
After 1 week.
After 2 weeks, you know, it may not be possible for me.
I may not be here
After
also
2
next
weeks.
week. I may not be here, Your Lordship, next week. So after the Easters, if it is possible.
Okay, whenever you want it, after 3 weeks. Yes. Mr. Vicky General, learned senior counsel today, submits that he has just been engaged in the matter. He prays that the matter will take after 3 weeks. Not objected to by the state respondents. This up to 3 weeks. Yes.
There's another item which my friend
Yes.
is mentioning.
So joint request, Your Lordship, for item number 32 for the private respondents.
After
2 weeks, Your Lordship.
what's one Nokma matter?
No, Lordship, it's cancellation of Patara.
Revenue matter.
These matters can be done anyway. No sense adjourning them. Anyway, okay. Yes.
After
2 weeks.
Your Lordship, I have a similar brief for item number 41. Your Lordship, there is
What's the matter about?
It's a advertisement for special recruitment, Your Lordship.
Not interested in the matter anymore.
We are, Your Lordship. There's a similar matter which is pending before this court, which has a bearing on this case, Your Lordship.
Which similar matter?
I'll have to take instructions, Your Lordship.
You should be aware what similar matter.
That matter is coming up in contempt, my lord. So we are.
Which matter contempt?
This is sericulture
No, which
department.
post? This one.
Lord, these are for the subordinate posts, not in the sericulture department.
The 2 weeks. You be aware also what is a similar case. Yes. Yes.
All right.
Your Lordship, I beg to mention item number 42, Your Lordship. It's fixed listed for hearing. Another 2 weeks may be granted, Your Lordship.
Why?
Your Lordship, the conducting counsel is actually traveling, Your Lordship, so she could not appear, Your Lordship.
This matter was heard.
Not yet, Your Lordship.
Okay, 2 weeks. Yes.
Much obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 28, Your Lordship.
Number?
28. I have filed my adjournment application on the ground that the conducting counsel for the petitioner has some personal difficulties.
You're for election petitioner.
Yes, yes.
You are still interested in the matter.
Yes, Your Honor. Just for today, Your Honor. Just for today, Your Lordship, yeah. I have sick for adjournment.
Because now in 25. Elections are due again in February 28.
Yes, Your Lordship. After 2 weeks, Your Honor, I have similar prayer for item number 30, Your Lordship.
28.
Urgent application, allowed for reasons to record it there. Yes. Yes.
Item number 30, Your Lordship. Similar prayer.
Who's for the other side? ZE. What's this? MR Rahman.
Lord,
Who's the other side? Number 30.
We are for the state, there's private respondent also. Mr. Sheikh is for the private respondent.
Yes. 2 weeks, okay, yes.
Much appreciated.
Yes.
Please, Your Lordship, I beg to make a mention of item number 40, Lordship.
Number?
40. I'm
Hold this
appearing
one.
on Mr. S. Thapa, Lordship. I'm appearing
I
on
can't hear you.
I'm appearing on behalf of Mr. S. Thapa. He's
The
having some
petitioner, yeah.
Lordship. He's having some personal difficulties, Your Lordship.
Ms. Thapa, the counsel. Yes.
What?
This is any objection?
No, no.
You want objection? Yes. What?
This is that boxing matter, man.
Okay, 2 weeks is boxing matter.
Highly obliged.
Yeah, please, Your Lordship. Item number 35. I'm for the petitioner.
What do you want item 35?
Since
Yes?
Mr. S.A. Sheikh is out of station,
other
Your
side?
Honor, I pray for.
Okay, yes, after 2 weeks, yes.
My Lordship,
Yes.
I apologize for what happening.
No, it doesn't matter. I want to
I
meet
want
your,
to
for you, send your senior colleague to meet me tomorrow, okay?
Much obliged, my Lordship.
All right. Yes.
May I please, Lordship? Actually, I beg to
It's
mention
not
this.
fair that, senior colleagues throw their juniors to the deep end of the pool. They should properly instruct them. You can't just tell them, go and appear and, appear of the High Court is a very important thing. It's not, even magisterial courts are important. Before you appear, you have to be aware of what the matter is about, what you need, what you want, and the practice and procedure of the court. Now what's happening is here you see juniors coming, they don't know anything, it's just the senior colleague goes somewhere, maybe he goes to have a cup of tea, sends them, go and mention the matter. I mean, there's total disrespect for the court also, for the time of the court. When we are juniors, even to mention is a big thing. We'll lose sleep the whole night if the senior says go and mention the matter tomorrow. Because if you mention at that time, the judges, we are too kind maybe. Adjournments don't come easy. And number one, before you mention, you have to know the matter from cover to cover. That is what is the practice in the High Court. Of course.
I apologize.
You don't need to apologize. That's why I do this. You can't just send your junior and say, go and mention. And the mention will be taken for granted. We don't want to be very harsh because we want to encourage juniors to argue the matter. If we are harsh on them, they run away and will never come back maybe. So you take your opportunity. If the seniors are there, you take the file, you read it. Okay, yes.
Lordship, this item number 37, Lordship. So I'm praying for 2 weeks' time, Lordship. I've already informed the other
Your Lordship,
counsels.
I'm appearing for
Yeah,
respondent.
objection.
No, Your Lordship.
Okay, yes.
Deeply obliged.
Highly obliged, Your Lordship.
Supplementary list item number 1.
Yes, Mr.
Please, Lordship, this is a contempt petition, my lord. Last time I have...
When the
there was
order
a-
dated?
Yes, the order dated was on the 30/7/2024. Then there is a direction
30?
clear... 30/07/2024.
Yes.
There's a clear direction, my lord, within to complete all the process. The para 6 of the page 12, my lord. The relevant para, Your Lordship, is...
Page 6.
12. Page 12. The relevant portion is, Lordship, that para 6, my lord. Accordingly, it is directed...
When did you submit the order to the respondent?
Yes, submitted the order on 5 August 2024. Now it has been more than 6 months. It's now 7-8 months going down.
Yes, Mr. P. Sharma issued notice as to why contempt proceedings were initiated against the respondents' name herein. Steps were taken within whether contempt proceedings were not initiated against the respondents' name herein for disobedience of the order dated
Order
30/07/2024. Yes, steps were taken by say in 3 days, just after 3 weeks. Yes.
Much obliged, Lordship.
Item number 2.
May I please? My lord, this is a matter regarding revenue.
Revenue?
Revenue matter, my lord.
Revenue from?
From Dwara Nongtrinam state, that is the Khasi state. What happened, as I have given my annexure also, the collector of the Sardarship has been collecting since 2018.
What is this customary toll?
It's a revenue for the land and for the house. So per care of land, they were taking 50 rupees.
For 1 year?
One care is about 100 feet by 100 feet. 50 rupees for one care. And for one house, 50 rupees.
For 1 year?
For 1 year. Since 2018 till 2024. This year suddenly...
You're paying that willingly?
Willingly we have been paying. Earlier it used to be annas and all, then it started increasing gradually.
This is imposed by the same. Whose authority?
Sardarship.
Yes.
Now, this year, suddenly the revenue for both land and the house has been doubled.
Now, this land we occupying, it belongs to
the state, Khasi state. They give us
how much?
pata.
100 rupees.
100 from 50 to 100 suddenly. That means this has been done without following the law.
What is the law?
My lord, in this case, law concerned is the United Khasi Jaintia Hills District Land Revenue Regulation 1953.
We have adopted the Assam regulation.
Yes, this that is what it says. It says.
Why? If you've been paying it willingly,
this law says
you
in
accept the authority
section
of
3.
You accept authority of the Sardar to impose this because you're occupying, you're cultivating their land, correct? So you're paying 50 rupees.
We had been thinking that it was going on according to law.
No, fine.
Earlier.
So now you're saying that 50 rupees, 100 rupees too high.
Not actually high. Our grievance is that the land has not been assessed. That is why, at the whims and fancy of the Mantri, the revenue has been fixed.
The assess meaning?
The land has to be assessed to revenue. As this law says under section 3, all the laws for the time being in force in the state of Assam under the provisions of Assam Land and Revenue Regulation 1886, Regulation 1 of 1886, and the rules and amendments made thereunder, subject to such time to time shall mutandis apply in respect of assessment and collection of land revenue in the district. Clause 2 says, all references in the said regulation to the provincial government, state government, commissioner, deputy commissioner, subdivisional officer and other authorities therein shall be construed as reference to the chief executive member or such other member or officer as may be authorized by him.
Aware of this existence of this act, this Sardar, or acting Sardar.
Sardar, no, it has been imposed by the Mantri.
A customary kind of levy on you for allowing you to cultivate the land of the state of the Sardarship. That's all.
The thing is that if it is assessed properly according to law, it may be more than 1 rupee also.
We have to be clear whether it is a customary.
Not customary. It is
customary.
Not customary. According to earlier also, it has been said that it is imposed by the district council.
By the Sardar?
Normally.
I don't think that will be the case.
People have been given to understand that way, my lord.
A customary toll or customary will go outside. This is not. It's not.
There is no other toll. There is no other revenue taken by the state.
See, even a traditional head has no authority to extract land revenue from anybody. You're aware of that. Khasi,
that report has to go to the CEM.
He's not a territorial sovereign. He is sovereign over the hearts and minds of the people. Territory is there. He's not a territorial sovereign. He does not hold any land. The only land they might hold, these little Sardarship, is the land which is within their control or which they own, or land or whatever, which they apportion to the inhabitants to cultivate. And in your case, since you are you're tribals, of course. Now they are just extracting a customary toll upon you. That's all. So your grievance is that they should do under the Assam.
There is no other toll, my lord. No other revenue. This is the only revenue we have to pay.
Okay,
for land.
Whoever, let them appear. Whoever. Yes.
My lord, let them come before the district council. Now, in this writ petition, their grievance is only against respondent number 3. Now,
let the district council come and clarify.
Yes.
No, because interesting thing is he says that thing, but it's not. It cannot be so.
No, the thing is that there has been no notice at all that it will be increased.
You do one thing,
Suddenly, okay, you have to give
file
100
resolution
now.
for the executive committee,
Yes.
and
We
you
will
implead-
examine it.
and you implead the Sardar. Okay.
Yes, my lord.
Yes. Take
I have implemented the
No, here, yeah, okay,
yes.
that's fine. Yes. The by way of the instant petition, the petitioners who are residents of Dwara Notre-Dame Sardarship, cultivating land belonging to Sardarship, are before this court assailing the levy and the enhancement of, what do you call it? Toll or enhancement of, we can't call it land revenue also, we can't call it land revenue also. Enhancement of
Khazana rep and
okay,
Khazana,
yes.
Khazana ing.
Yes. Khazana rep, just given Khazana rep within small letters, that means,
Khazana ing.
It's, and Khazana ing means levy on agricultural land and levy on house, on dwelling house. Stop. Next paragraph. Submitted by Mr. P.K. Bora that the levy by the respondent number 3 is without any authority, inasmuch as the land has not been assessed as per the United Khasi Jaintia Hills
District Land Revenue Regulation
Land and Revenue
1953.
Regulation 1953. He therefore prays that directions be issued to stop this unauthorized, or no, to stop this extraction of land revenue or khajana, whatever, house tax, by the respondent number 3. Stop. Next paragraph. Mr. Titindo, learned senior counsel appearing on behalf of the respondent, one district council respondent, has submitted that whatever grievance the writ petitioner has first has to be placed before the executive committee, inasmuch as the whatever grievance has whatever grievance the writ petitioner has against respondent number 3 was Sardar is to be placed before the committee, the committee's council for redressal of the grievances. So, as far as Mr. P. Bora, you accept that?
Yes.
On this submission, prays that he may be allowed to withdraw his petition and to prefer
the district council
proper petition before the district before the executive council. On these submissions, because accordingly, stop. The writ petition stands for withdrawal. However, liberty given to the writ petitioner to approach the executive committee by way of appropriate application.
Item number 3.
May it please your lordship.
Yes.
Lordship, in the year 1987, the relative of the respondent has taken money from the
in the year
1987.
87.
87. In the year
Who took money from whom? The respondent.
The relative of the respondent has taken money from the mother of the appellant, lordship, and mortgaging a plot of land, which is the suit land in the trial court, lordship. And then thereafter, lordship, the agreement is that to the fact that in case the money was not returned within a period of 10 years period, then the land would go to the mother of the appellant, lordship. But then the money was never paid, and then later on, lordship, a title suit was there in 1982. No. But then the mother of the appellant did not take part.
Was filed by whom in 1982?
Was filed by the respondent.
By the appellant?
No, Lordship, by the respondent, Lordship.
By this miraculous withdrawal only?
Yes, Lordship.
Then what happened?
And then the mother of the appellant did not take part because the 10-year period was not yet over. And then the land was always...
No, that suit was filed for declaration of what? That she is the owner of the land.
Owner of the land in connection with, not particularly for the suit land, but other landed properties such as paddy field and other, including this plot of land, this suit land, Lordship. And then thereafter, Lordship, the land was always in the possession of the mother of the appellant. Later on, it was devolved upon the appellant. Then later on, Lordship, there was no dispute as such, and then there was no disturbances whatsoever from the part of the respondent. But in the year 2022, she has come and trying to claim back the land, which was mortgaged. That money which was taken was never returned, and that mortgage land was there, and then she came. And then we have filed, the appellant has filed a trial suit before the trial court, in this council court.
So what happened to that suit filed earlier on by the respondent? It was decreed in her favor.
By the?
No, you said the respondent filed a suit for declaring
decreed in their favor,
decreed in her favor.
In their favor.
So the decree still stands, not challenged.
It was not challenged because...
Oh, you made party in that suit?
I was made party.
You didn't take part?
The mother of the appellant was made party.
Okay, your business interest. You didn't, mother didn't take
no,
part?
Lordship.
We didn't... The decree was ex parte against you?
See, Lordship, that suit was filed in connection with other properties.
Fine, but the decree was ex parte, or you took part in the proceeding?
We didn't take part, Lordship.
Okay,
the mother of the
decree
appellant did not
stands.
take part, Lordship.
Now, now after how many years you filed this fresh suit?
That is almost after 30 years, Lordship.
After 30 years you filed a suit?
Yes, it was filed because that land was never, that particular plot of land, which is small, that particular plot of land was never been disturbed. It was always under the possession of the appellant.
So when she disturbed possession 22, you filed a suit?
Yes, Lordship.
Then what happened to the suit?
The suit was dismissed, saying that you have come after 30 years, as your Lordship pointed out. And then actually the cause of action survived, Lordship, because that particular plot of land was mortgaged to the mother of the appellant.
Now your case, you were always in possession of that land?
Yes, Lordship.
And they disturbed possession, and so you filed a suit?
Lordship,
now
yes,
what happened to the suit?
The suit was dismissed, and then we have appeal.
Yes, you appeal.
We appeal, yes. And then again the learned appellate court upheld the judgment of the trial court, Lordship. My concern is that, Lordship, actually this matter should be tried by the trial court below, Lordship, so that to come into...
Let's hear them up here first. I heard Mr. H. Clark issue notice returnable in 3 weeks. Steps to be taken by said AD within 3 days. Listen, so. It was dismissed on what? It was upheld on what ground? Res judicata?
That's what they say.
They used that old decree that had already been decreed.
Yes, Lordship.
Item number 4.
Tough call, yes. Yes.
Item number 4.
Lordship, we have prepared an application.
Yes, further application.
Lordship, we are being led by Mr. Paul on this matter, and he's currently out of station due to some personal difficulties.
Where's Mr. Who's the other?
Thapa,
a whole regiment of people.
Thapa.
Lordship, he's also having personal difficulties.
Now, next in command is whom?
Lordship, I'm paying for a week's time, Lordship, on this matter.
Well, kindly see the orders it matter. Fixed on 1st, then on 3rd, and today.
Lordship, hearing is to be done on the miss case, and Mr. Paul is...
My lord, otherwise, in view of 2263, my lord...
Let's see a miss case? You have the file with you?
Lordship.
Very good, yes.
Lordship, I'm not the conducting counsel on this matter, Lordship.
But you're standing here before the court.
Lordship, I was on limited instructions, your Lordship. I'm just praying for a week's time, Lordship.
Where's your miss case?
Miss case
477, no, miss case number? Is it miss case number 21?
Miss case number 21. But if I may take it also, Lordship, to the order, my lord.
1 second. Yes, Mr. Who's up in the state?
I'm there.
You don't dispute that there was a second order allowing the
appears,
selection.
Lordship. It appears at the
No,
time.
I mean it not appears. Are you under instruction that it's reliable?
This letter is
Lordship, yes.
Captain Obeyance. No, cancelled.
Cancel. That has been
We
cancelled.
have it after some time. You call, you get a council's conducting it because it's a application, and then for
Lordship,
vacating
I'm
it's
just
been
seeking
adjourned.
for a week's time, Lordship. Just a
Yes?
week's time. Because
2 weeks time?
Just a week time. 1 week, Lordship.
Then let come on Tuesday on 8.
Lordship, just a week's
This
time.
is November,
because
Come now. No, today is
Third.
we take up tomorrow. You bring Mr. Thapa.
Lordship, just a week's time.
My lord, the Lordship gives one observation
Because
that
he's
because of
also having some personal
226,
difficulties
influx of
and-
time, my
Let's
lord.
take down
Just a week's time, Lordship.
this application has been listed 2 days. Where's the order? You file a reply.
I'm on
They
limited
file a
instructions.
reply to the objection. They file.
The file reply. Reply filed on 6th March, my lord.
You can look at the reply without counsel, doesn't matter. Where's the reply?
They're only saying this is an afterthought.
Okay. We'll have on Tuesday. Yes, though the matter has been fixed today for consideration for vacating of the interim order. Stop. And it is noted from the order sheets that the matter has been adjourned from time to time. Stop. Adjournment has been sought on behalf of the writ petitioner due to the absence of the arguing counsel. Stop. And the same is vehemently objected to by Dr. Muska appearing for the applicant. However, in the interest of justice, this is matter as this on Tuesday fixed matter understood that notwithstanding the difficult, it is understood the next day the matter will be taken up, miscarried and disposed of. Yes.
Obliged.
Item number 5.
After taking stay order.
May it please your lordship. Lordship, as sudden development is there, your lordship. A few job holder, your lordship, they file a complaint before the Lok Ayukta. Lordship, kindly come to page 7, internal page 7 of the report. Page 7, your lordship. Kindly see, your lordship, the last paragraph. Hence, a criminal case of forgery and misappropriation of fund is clearly made out. This fact has been concealed, your lordship.
Your Honor, of the report.
No, lordship is aware, your lordship, because this is pending before the Lok Ayukta, your lordship.
Yes.
Today, Mr. Initial Learned AAG has produced for his court inquiry report in connection with a complaint before the Meghalaya Lokyukta.
Lordship.
Shillong. A perusal of the inquiry report shows that it has a grave bearing on the petitioner before this court. Stop. Ms. S. Marpana, correct?
Yes, Your Honor.
However, on behalf of the petitioner submits that she is without any instructions, nor is she aware about the. You're not aware about the proceeding for
Aware, Your
Lokayukta?
Honor.
Then
It's still pending in the
aware about the
Lokayukta,
outcome of the
but then-
inquiry.
That fact has been concealed, Your Lordship.
Inquiry. This is matter after 1 week.
I'll
To enable her to open instructions. You.
Offline.
The report taken on board. Huh? Yes.
Item number 6.
May I please, Your Lordships?
May I
This
please-
is an application
Your
by
Honor.
the university
May I please, Your
for
Lordship?
extension of time because the matter was disposed of by Your Lordship, the writ petition, with the direction that the case will be considered for promotion subject to availability of post, preferably within 6 months. Now, in the meantime, what happened, Lordship is aware about the disruption in the university, my Lord. We are unable to convene the. So
You mean everything is stopped functioning?
Now, my Lord, things
Are
are.
the students getting classes?
No,
taking
now it's all
classes?
right, my Lord. Now the normalized situation has normalized. Now we want to do it, but in the meantime, substantial period has passed, my Lord. So we are seeking at least, my Lord, some time, more time.
Your Lordship, I have some submission. That let the notice be issued to the respondent as they have returned back the files, and also, Your Honor, let
Or you? Oh yes.
the notice be issued.
See what they'll do. They're helpless. Yes. This is an application in this case, huh? For extension of the time allowed by judgment order dated 25/9/2024 passed by this court. Stop. Issue notice to the respondent within 3 days. Is thereafter. We won't record anything.
Same thing, my Lord. Next.
Item 7.
Disconnect.
Once the name is recorded, then we'll keep on paying the list.
Well, similar.
Yes.
Daily list item number 1.
My Lord, item number 1 and 2 is a contempt petition, and the appeal is also listed today, my Lord.
Yes, correct.
Yes, Lordship.
And my Lord, they have corrected the name of the officer also, my Lord, in the item number 2, the present officer. So I'll be appearing for that officer also, my Lord.
Which officer number 2?
My Lord, I'm entering appearance on behalf of the newly implemented respondent, my Lord.
Number 3?
Number 5.
5 is the number 5.
AG also got a letter. Yeah. You got the letter from Lafayette also, yes.
There are 2 and 3.
No, Your Lordship. The finance department has been made a party along with the.
Right, number 2. That's number 2. And secretary PWD at number 3. Where's 4 and 5?
We already received letter. Yeah, we already received a letter. It's there with complete.
Where's 4 and 5? There were 3 respondents.
4 and 5.
There's no 4 and 5.
4 and 5, Your Lordship.
There are 2.
You kindly
They are newly implemented
see
respondents.
in my petition.
Yes, my Lord.
We'll
Newly
report.
implemented.
It'll be
Yes,
4,
see.
Your Lordship.
You see.
Secretary Finance and Secretary PWD. my Lord.
See, Mr. Bhattacharya.
Yes.
There's 2 and 3, not 4 and 5.
My Lord, there will be altogether 3 respondents.
My Lord, the notice it says 4 and 5, my Lord. That is the problem.
It's the same number. It's WC number. See the notice?
Yes, my Lord.
This is 78. This is a different case.
My Lord, item 2, my Lord.
In item 2, Your
At
Lordship.
least you kindly say that. MSR only submits that in this matter, item number
1, my Lord. In item number 1, my Lord, we have 3 respondents.
Yes, item number 1. MSR only submits that she'll be representing item number respondent newly implemented 702 also. Mr. K. Varshadi, then the GA also submits that he will be representing respondent number 3. Yes. List after 2 weeks for affidavits. Oh, it's before the revision bench. It's after just list after 2 weeks before the orders. Other matters, same thing, 4 and 5.
Item number 3.
May it please your lordship.
Your Lordship, we filed our affidavit.
Your Lordship, may I please, Your Lordship, I have received all the affidavits. I humbly pray 2 weeks to file rejoinder.
Yes, legal counsel for the petitioner, Ms. Simpson. Please for 2 weeks and for rejoinder. Affidavits filed with respondents. This thereafter and so and so.
Obliged, Your Lordship.
Item number 4.
Your Lordship, we require some more time, Your Lordship. We have not received any instruction from the respondent number 2.
How is saying that when the last submission was
Yes,
that
Lordship,
the
but
records are voluminous?
But it's not from the respondent number 2.
What is respondent number 2?
Personal department, Your Lordship.
What's the matter about?
Termination of service, Your Lordship, regularization.
Answer one praise one allowed for a 2 weeks time for affidavit. This thereafter and so and so.
Your Lordship, similar matter for item number 4 to 9 and item number 12 as connected matter.
Number?
Connected matter, Your Lordship.
4 to 9 and
4
12.
to 9 and 12.
It's 12 to 16.
4 to 9 and 12,
12 to
16.
16.
Okay.
Which will be?
Item number 10.
May it please Your Lordship, we have already filed a rejoinder.
So that's our hearing.
Yes, sir.
Party submit any submission to make.
Lordship, I'm appearing for pro forma respondent number 11 also. That is political counsel for technical education. No claim for relief has been sought against us also.
Yes, Mr. S. Pandey submitted appearance today on the respondent 11. He submits that there is no claim for relief against from the evidence as such, no effort before coming from the respondent's term. Like para parties for the submit that the pleadings are therefore complete. Next line, upon this matter for hearing after 2 weeks.
11.
Yes, file affidavit.
Yes, Your Lordship, it's fine.
What about 1, 2, 3? You want to file a joinder?
Yes, Your Lordship. We haven't received
Yes.
the counter affidavit yet. Your
Yes,
Lordship.
so please for about 2 weeks time for the joinder. Will somebody after it's filed by the respondents?
17.
I filed today only.
No, Lordship, we filed it yesterday.
17.
All right.
May it please Your Lordship. Your Lordship, I'm praying for 2 weeks time to file our affidavit.
4 and 5.
I'm on behalf of Madam Ailingwa.
You file affidavit?
No. Pray
Yes,
for 2
what's
weeks.
the matter about?
Your Lordship, it's the matter about the interstate seniority of the PhD department, Your Lordship.
MS said into only for 1, 2, 3 and it's even for 4 and 5 pretty for out for 2 weeks time to find affidavits after and so on.
Obliged, Your Lordship.
18.
The district council has filed the affidavit.
is already filed. So,
Yes.
The inquiry report is on record, Lordship. They had filed an affidavit.
So now we'll dispose of now only.
There is a
Lordship will have to peruse the report, Lordship. Inquiry report.
Why you stopped me from producing the report here?
Lordship, because they have raised the same set of allegations, Lordship, which has been dealt by the first.
I have filed an application, my lord, for vacating the stay order. This
Right.
was filed, my lord, 16 December, my lord.
Let's see after it's a
4
council.
months. Well, this is a case of my lord, loss of confidence, my lord. I am
There's no
representing
loss of
four-
confidence,
My lord, that I'll show you, lordship, how it is.
Just relax. Yes. Where's the affidavit filed by? Respondent number, Marpan?
respondent number, respondent 1-2. 1-2.
In the main case you filed?
No, in the miss case.
Miss case 218, Lordship.
218.
So out of 10 Lingdo, 7 are also confidence.
No, 5.
Oh, 5,
so
sorry.
I've just
7
para
Lingdo,
number-
7 Lingdo
para
and
number
3
three, Archie.
the 10 electors, 7 Lingdo and 3
7
Mintris.
Lingdo, yes.
And
Out
out of
of
that, 5 Lingdo have lost of confidence.
Yes.
What are Mintris? Mintris have confidence in you.
Yes, Lordship. So
There's
3
no
Mintris and
formal,
2
there's no
Lingdos.
formal correspondence or anything as such that we have received. We have not received anything to support that they are supporting the petition.
Only
There's
5
no as
Lingdos
such.
are before
This
your
is the
Lordship,
formal
which
complaint.
shows that
There's
we are-
nothing formal. Maybe verbally, but nothing formal to support the petition.
Lordship will appreciate one thing, my lord. Even if your lordship include the mantris, my lord, it comes to 10. Out of 10, my lord, 5 I am representing.
No, we're
They have
not,
lost
we're
the
not going to
confidence.
count numbers here, Mr. We're just seeing whether the manner in which if he's alleging double jeopardy.
No,
which
it's
is
not
not
correct.
correct. Exactly.
In the
It's not
sense, in the
correct.
sense that on the same inquiry report, you had suspended him once and then reinstated him, and based on the same findings, whatever, you have suspended him again. So court is just going to examine the legality of the action of his suspension. That's all. So you have to convince the court. You have to convince the court that the second round by which he was suspended is based on different set of materials.
Exactly, my lord.
That is
That is my. I have, my lord, in my application for vacating stay, my lord, I have annexed all the documents plus the order. Order was not challenged. Initial order. District Council has very categorically stated we have taken notice of a complaint dated September 2024. He was reinstated, my lord, in the month of March 24, and September 24 there was a complaint by these 5 Lindos, your lordship.
Yeah,
Here,
his
my lord,
allegation is that it's same complaint.
no, exactly. Totally wrong. After assuming office, we have stated categorically, after assuming office, after his reinstatement, he did a series of things, my lord, which is not conducive for this now.
Well, let's hear him first, yes.
Lordship,
I'll
can
just
you-
get end of the board.
End of
Will
the
you-
board.
yes, before the hearing. You prepare yourself. So it'll take some time.
19.
Just wait, briefly, for my opinion.
Yes, Mr. Dukrut, where's your client?
My lord, they are here. My lord, they are here.
And where's the respondent? Mr. Pasanti, your clients come? And where's your client?
But the respondent number 4 have also filed an affidavit. Your lordship is the affidavit filed by respondent number 4. Respondent number 4 is the headman of Motlong. From this affidavit, it would appear that the petitioner had all along allowed means he's participated in the construction of the road. He was a member of the committee. All these have been there.
My lord, we have made very clear in para 5 of our main petition that this was because of the threat. If I'm not allowing them, I didn't give them illegal property, they will ostracize me from the village and they will not allow me to work in a Manrega scheme.
Okay, see, we need assistance of the council also. Mentara ni kajaka, pidi de sinong you, namar nakadikatan you ka sinong gani?
Motlong, Musa.
Na motlong munsan na hey ka motlong karon.
Siya tayo siya, masiling mo sa daw.
Okay, nasa daw. Pidi rumah sinong, sadar sinong. Di menta, bro asyikata kiperan kambit baniyat na po lijaka jang pipiong.
Yang ni susya.
Absua an ay keren cuy gini.
Borok cakap tinggal jawan binata borok.
Absua kan klis cuy gini. Borok pilih jawan baik nang tergelinti. Pisah iki nang song senong begini jawan tergelinti.
Ni susya banlay tang balong bun kami kerja pengam ai.
Em kamdan ngata ka jikli bon pun kam jaka. Henry pisah begini ban begini ban wan tu jaka.
Ni sya banlay benwan tang balong bo.
Di menta pat piwan ujur hakakur ban ong ba tu ka surok menta gimur penlek ban pen long surok ya kali.
Oh, gelong kilek don bor, kilek bahaya kamu lagi tuj bagi moy dah kerja subi. Klem kono kajing ya, merjing mut berling. Kata kanya pan sekakut bakamut long ngilak pai, seurung bak senong lo ulek dah kabor. Halur sakhi kababiang. Tingi pai sekahima long kakain bain teman. Bang adai urum ruai, bang idai urusiyeng. Te irusiyeng ro idai muslim bro te nga ong.
To nang tahu pi kedai di shisha bang ini. Nampak apa mut pihak perenkam sok balik awan. Tementai penhek ke surok pihak lihat ke bor, ke GCB ban penhek surok.
Itu sahalang bala kasih menekang cor pentre surok lagi pentre dengan ke MG.
Kapan saya kini kita
ke hapar botre ini ro atar poka skim ke cepat ni ide member letrelang kau dislangi lah ai bidar intrat saya tra jangan lah semilut kau dislang tu te ladu botre nongkong ro ini trelang te hapka harut jing ini ro yang bayo ka tu kendo ikwa kendo ka senang ka pen kendo ya kata ro
tak kamu jinglong try jong i pikir teng menung tu dondor jana di kong ne oh to jinglong try jong gini kata pim kam dei jaka senong kali jaka jong ki piperon kam pim bot kiong kini piperon kam jubor bar pim da lada pim deki menjur bakin ban ai peron kam bagi senong ki pia touch senong iki risisa kata
yang tak jung touch nong de sarpen ma.
Touch nong kalau persakaan.
Touch ma tak jung touch nong de namar gede ki be ramach nong tik mandai ngacepet ki record kam don te touch nong. Te hang tu apa
di touch nong bakam kim sha shu bakin sim bentai tiki kam penrai apa nong. Banyo jementai ki
record apa register. Te kam don katakan touch nong. Si om bakal nong haba hadin bedan dot ipentut gadorbar kabun ocipor hero. Tang kata ngalap
kalau kata lat bro hewan berlangut hewan di film ben ya kani ka mafi film kuah cuma nak surau iki
kain sahab badan muram pi ubadai unong sinsar ya ka hok ya ka dustur ublai ai tu ya phui ba pinsong ka khat ka buhe bahai ngi ong umne la ka lingi ka yung kamu ni lapan baj baria ini jaka bangi thi ni mang iki khoni kitoi wat isanaya punya yang pelang
em kata bakawan hakut de kata tang ji ujor jung pi pangakwa aban tip ye ka jing shisha narang ong khat haba lengba kipida kila batai ka ju ong pi ndai ngon ra ai pi hang ni nga pha wan khanang mdei ban pensutom pi ni kum do ban wan lam wan ra ka jing sung thu pelada pila nem bania poi ha ka jing sung thu ba fini song suk song san ha po sunong tang kata bani kan at kum ni mut ka jing bentuan juga song hiap pek jing bentuan le dir hiap pek
sahab
ti wat mut bangap khat hang ni pi bangan pensutom ni bangan pha jadi mdei kata ngas kwa bani so kata ka jing ut jing nam jung pi ba pi ong ka le ben ka snong da ka liang usnong ka ibi do mon ong
sahab buram lingangang ong ba da ba usnong ulo uisha ya kata ka jaka ban penenkam te ai la te yang ba ai no de keling ne
pila ban siu
harus senang dalam don besar kumata tu bangsu kan. Nama besar ketika surau
MNGRS tu surau pisna menta. Kahek kan no kadang no kajingjrong.
Ketika surau sar ke nadu na apa pribudi siapa bekut tajong ketika
kan no kajingjrong tu surau.
Kadang gemba 4 kilometer duna.
Kan kilometer kaya. Dan cakap jongki kan no mitar.
So
put ne mitar.
Mitar so.
So dokur you can
put.
Put. Siu do no iki again.
Meters of foot.
Kan no ka width.
Meter.
What's the width?
Width is 9 feet.
9,124.
Ketua sar chwa ban mentre chwa mde mentre da kan no skin mentre da ka motorut. La tu pasang batre tak surak. De nadu nata ku bula sedang ti atau surak umdan bapenhe umdan bapendit da.
Em kata mensuar kim bapilek kiong bapilek jubuar menta bihona GCB penhek banyak kali ya kata ki persya
em kata jung penhek te sarhadu menta kam
penhek yes Mr. Dino
takan long sahab tikinong tre ka mensuar kila ong
pi tre lang berkine perhek nusrok
muti ong kumne
pio bainong ka tispas ngi pi pentre lang nusrok
kamu nak ikut ngayon saya tang balong kiong baka jaka deka ongfoy. Tenginam kam. Bat sebang nginam lek don bor ka kadang ko poro da klem da fisi kitra ki bathit ke ya bisa ka ori ku jaka.
Can they circumvent a road?
From what I can understand is that they're not really against
it,
but they want that the Shillong should should recognize that the land belongs
No,
to them.
can they give them some token? No. What to say?
Sahab, itu yang saya kemudian hapon
Mentah
long
kalau
lepas senang
ni, fi keteng kumno.
Keteng ipi.
Keteng.
Starbel maulong.
Taral molong.
Dengan pensiap syukur kendit bentayi unang kendong ubah kendit pendap. Hakapon bi 4 long lepas senang lagi ong to nya khang dam no ya kini kejekang iwan tak meeting hiing.
So,
So, mentan lalong rong ba senang pak.
You just take them out. You just try to talk to them. Lada, they want recognition only from the village darbar that that they are the owners. Then let them pass the resolution. Just talk to them. You just go and like pilih bagi pidang pasyabat. Askur langsung tu kayak kata ka hei kesan. Take ni persang ban pini pensung tu hendet. No, sawan biang hadiah setengah ta. Give them a cup of tea or something.
Item 20.
I'm praying for time, still awaiting instructions.
Yes, after 2 weeks for affidavits, correspondence.
21.
Lordship, this 21, 22 are connected matters also. The respondents are yet to file their affidavits.
21 and
22.
Lordship.
Is acquisition
Lordship,
matter?
we're praying for 2 weeks
Compensation
time.
matter
Lordship.
also.
Similar prayer on behalf of respondent 7 to 9.
Where's Pibu Sokarma?
Lordship,
appearing this matter? Or you appearing?
Lordship, I'm here.
Last time she allowed open instructions and what instructions?
Lordship, here what happened is that in the last occasion, the collector was raising this issue that the parties should go to the reference court, Lordship. But here, Lordship, the issue is we are challenging the actions of the collector, Lordship, his review of actions, Lordship. Because under the Land Acquisition Act, Lordship, he has no power to review his award, Lordship, which was earlier passed.
Why are you seeking more time?
Lordship, we have not received any instruction from the...
Because that time submissions have been made, Advocate General said he puts objections on a form affidavit.
Lordship, but the instruction from the collector we have not received.
What? Annexus 15, Lordship, if you see.
Yes, you give them 1 week for the time. By order dated 12/3, it is recorded in the order 12/3/2025 that the respondents were to put the objections in the form affidavit for the next date. Stop. However, today MSS Ladu for respondent 16 please that further time be allowed, as they are not yet receipt of proper instructions. So accordingly, this is matter after 1 week or 2 weeks.
2 weeks, Lordship.
Okay, 2 weeks, yes.
Obliged.
Expected that next date objections should be on board, yes.
Much obliged.
23.
Wait, please, Your Lordship.
File.
No, Your Lordship, I'm praying for 2 weeks' time.
As a private respondent, I have filed my...
What's the matter about?
This is about several complaining, Lordship. Multiple complaint and
Domestic violence
domestic
matter,
violence.
Your Lordship.
It is a?
Domestic violence matter, Your Lordship.
Oh, to put in one case.
Yes, Your Lordship.
The matter still proceeding all those different forums.
No, Your Lordship. Only on we have already withdrawn the complaint that was filed before Tura, and we have proceeded with the complaint that was filed before Iskasils, and that matter is proceeded now. It's pending for orders in the court of JMFC.
You file affidavit in 1 week.
Yes,
You already filed affidavit.
Yes, Your Lordship.
Yes, Mr. Ujoshi for respondent submits that affidavit on behalf of the said respondent will file a message inventory for 1 to 8 days for allowed further 2 weeks time. Just after 2 weeks for the orders.
Obliged, Your Lordship.
We'll close it on the next date then.
Yes, Your Lordship.
24.
Your Lordship, we pray for 2 more weeks' time to file a affidavit. This is regarding those forest dwellers. They had encroached on the forest, reserved forest.
Oh. The submission you make is in the forest dwellers. I mean, recognizing the right of forest dwellers.
No,
Under the
actually-
Forest Act, they'll have, an actionable claim against you. Yes.
2, 7 and 8. We are representing 2,
Yes.
7 and 8, Your Lordship.
Yes. 1, 3 and 6. Yes, MS Emershang by Dr. Mbozika for 1, 3 to 6 and MST Yangi
2, 7 and 8.
also for 2, 7 and 8. Pray for not for the 2 weeks time to file affidavits. You build concrete houses inside the forest?
Yes.
What kind of forest dwellers? Yes.
25.
Lord, FCI had filed their affidavit on the 24th of March. We've prepared a rejoinder. We're filing it in the course of the day.
This matter, tender matter?
My lord. The debarment
You're
notice.
appearing for whom?
For the FCI.
For number 2 to 4?
2, 3 and 4.
Yes, number 1. Yes, Mr. SN submits that to the affidavit filed by the respondents 2 and 4. Rejoinder will be filed in the course of the day.
I'm making a humble prayer, my lords. What's happened is that the interim order the lordships had passed, they're being extended from date to date. There's some looming uncertainty when they participate in other tender matters, my lord, because they have to disclose whether there's any debarment issued by any other company. So this creates some sense of uncertainty. If your lordship will kindly make it absolute till the disposal of the matter, can be taken up.
When we're going to what this tender, when is it closing?
This would
only
so for the other tender, I'm talking about the other tenders, my lord. For FCI and other departments, we have to disclose.
Other departments.
Yes, my lord. For other departments. So because we have to disclose if there is any. Yes, ma'am. Blacklisting. Correct.
Okay. Yes. Yes. Interim order shall continue to look for the orders. Yes.
Lordship, highly obliged.
26.
May it please, Lordship.
Yes.
Lordship, I humbly pray the matter may be posted for a hearing. In the meantime, we will file our reasonable affidavit.
Yes, Mr. Coach, this matter we're hearing. He undertakes to file the rejoinder in the meanwhile.
This matter is connected with the next matter, my lord, 27. So this both the matter may come together, my lord.
Yes, just together it will be 283 for hearing after 2 weeks.
Second call 18.
Ada apa? Tapi hearing it done. Yes, Mr. Sen. Let's have your application.
Lordship will take up my miss case. 222 of 222 of 24. There are 2 miss cases, one by District Council and one by the 5 Lindo electors, my lord, who were subsequently impleaded on an application filed by us.
Which numbers? Sorry?
222, my lord, of 24.
Where did you find the application? Huh? Mr. Nongpir, you filed objection to this?
I didn't file it because the observation of the court was that this honorable court wanted the inquiry report. That was the order passed, lordship. There's no affidavit file. There's no counter affidavit filed by them also, lordship.
So 218 is filed by
218 is filed by the district council.
For what?
For vacating
to set aside the first order.
Vacating the interim order, lordship.
Interim order.
So both of you the same
both
page?
of them they are filed.
Okay, then fine, yes. So should we hear Mr. Mararan first or you here first?
We can do, my lord, District Council.
The District Council is the... Okay, 218 first.
218.
Yes.
Lordship, the first complaint where the writ petitioner was suspended, kindly have a look of the complaint. That is at page 33 of the writ petition.
Writ petition. Okay. First complaint is?
This is the first complaint. This is the order, in fact. Sorry.
Page 33.
33 is the ground.
11 April 2023.
So this is the order of first suspension, Your Lordship.
Okay.
So this on two grounds.
423.
Yes, sir.
Okay.
So on those two grounds, Your Lordship, the writ petitioner was suspended.
Firstly, that he has tried to change Nongpo Elaka to
Yes,
Saintship.
he's tried to change the Nongpo Elaka, and the second was that he's failed to work together
Yes.
with the rights in his appointment. So after this order was passed, there was an inquiry which was conducted, Your Lordship.
Yes.
After the inquiry, now the inquiry report is there, Your Lordship. You can peruse that, Your Lordship. After the inquiry report, he was reinstated.
Page?
The reinstatement was order dated 4th March
So where's the
2024.
inquiry report?
The inquiry report is that one which is in the miss case. Additional affidavit to be filed.
The first inquiry report.
Yes. So he was reinstated. He was reinstated by order dated 4th March 2024.
Lecture?
That is at lecture. Page 57, annexure 10, Your Lordship.
Okay. Annexure 10.
Yes, Your Lordship.
Okay. What does it say?
So it has, based on the inquiry report, the last portion, Your Lordship. Page 57, the writ petition, annexure 10, Your Lordship.
Yes.
It has, based on that inquiry report, the last portion thereof. Therefore, in view of the findings of the inquiry report dated 14 December 2023, and for the interest of the HEMA, the Executive Committee is pleased to revoke its order dated 11 April 2023, thereby reinstating Shri Wanprang's CM Nongsha as a Sadar, Nongpo Sadarship. So after this order, there was complaint filed again by the Dumdo. Now this complaint is at page 63, Your Lordship. Page 63, Your Lordship. So they are against the reinstatement.
To reinitiate inquiry.
Yes. So that is what the subject says, reinstate. So this was one complaint. Then there was a reminder
Now, one
to
second.
this.
Where the complaint? I mean the charge. I mean their complaints. What did
This,
he say?
this is the first complaint, page 63.
Oh, 63 is the second complaint. I mean after the
Yes, after the reinstatement, this was the complaint at 63. So basically, in this complaint, they're saying that they had asked for some copy, page para number 6.
See, one second, you just see, Mr. Marpan.
Yes.
That at point number 7.
Yes.
Without following due process. Meaning,
Yes.
See, that despite numerous requests made, the chair complains the inquiry officer did not supply the charges framed as a person concerned. Instead, the complaint file is with us. Still, there no formal charges were framed. The committee will supply the complaint. Hence, the committee is not able to take necessary steps to take part in inquiry. So, are they aggrieved with the inquiry or?
They are aggrieved with inquiry. Looking at this letter, it looks like they agree with the inquiry. Now, after this 63, there's another reminder which was submitted by the Lengdo, that is at page 67 of the writ petition. This is a reminder again. Reminder they demand to reinitiate the inquiry again against the writ petitioner.
So that means that in their fresh, demand, they didn't state any charges at all. Like in the first time, he was suspended because he tried to change Nongpo Starship to CM-ship, and number 2, he never worked with and never had Darbar, and so on and so forth.
Yes.
So those two charges, he was suspended pending inquiry.
Yes.
Inquiry was conducted, he was absolved.
Yes.
And he was reinstated.
Yes.
Now these people have come again, Mr. Sen's clients.
Yes.
To reinitiate, that means same inquiry.
Same
inquiry.
Looking at page 63, yes. Yes.
Let him finish.
So they have sent a reminder again after page 63, right, 67. Then again another complaint. That's an application against appointment. That is at page. Can you see, Archive? That is page 69. That an application against reappointment. So taking these 3 letters or complaint or representation, reminder against the reinstatement, we have brought these 3 things and brought it to the knowledge of the writ petitioner and allowed him an opportunity to give a response to this.
There are only 10 electors, Nongpo, Sadaship.
Yes, only 10. These are the main electors.
Okay.
So all 5 of them had submitted this. So we brought this page 63, 67 and 69 to the knowledge of the writ petition to explain. So he has given his response, that is at page submitted at 76. This is his show cause at 76. And this show cause was submitted in the month of October 2024. After giving him opportunity several times, he had asked for adjournment, and finally in the month of October he submitted this show cause. After this show cause, there was a...
1 second, let's see the show cause. Okay, yes, next.
After the show cause, there was a hearing. Both parties had appeared. They have appeared on 24th September 2024. After hearing both parties, Your Lordship, they had submitted written argument. So the written argument dated, this is one written argument by they have supported, they have also submitted.
No, what's this then? You come.
Now 3 observations were made. That is the second suspension order.
Yes.
Now that
Where's that?
enclosed with the my miscase, Your Lordship.
You need 218.
Yes, 218. That order was passed after that hearing. Your Lordship.
Yes. Page
8, annexure 1. There's only one annexure. Now this order was passed after that hearing on 24th, yes, 24th September 2024. The order is 2nd December 2024. After hearing both parties, Your Lordship, you can see para number 2. Based on the complaint petition as received, the matter was heard on 24th September 2024, during which both parties are directed to submit their written arguments within 10 days. Consequent upon, written arguments were submitted by the complainant on 27th September 2024 and 4th October 2024, whereas the Sadar submitted his written argument on 3rd October 2024. Upon examining the materials on record, the following observations are made. Now, 3 observations were made. The first observation was that Shri Wanprang CM Nongsha, which is the writ petitioner, was reinstated as Sadar of Nongpo Sadaship by notification dated so and so. However, it has become evident from numerous petition and representation by the Lungdo Raj and the Longsan Mansan of the Nongpo Sadaship that the Sadar has failed to gain the confidence of the electors. That is one. The second one, the lack of confidence has created a deadlock in the administration in the Nongpo Sadaship, thereby impeding the smooth functioning and affecting the interests of the Ilaka and its people. In the interest of the administrative justice, to ensure that continuity of governance and to address other grievances of the elector, it is imperative to conduct a fresh and thorough into the matter while also taking necessary interim measure to prevent further administrative disruption. Now, in this order, an administrator was also appointed to take charge. So, Lordship, this order is just suspending the writ petitioner, just a measure to ensure that there is no, to ensure, Lordship, in my
So you
miscase I
mean to
mentioned,
say that is amounts to
enable an impartial inquiry.
review the early order, this order?
No, because the Lingdo, the majority
See, Mr.
looking
Barbara,
by.
you have to understand one thing, that this second round of inquiry was at the at the behest of the disgruntled elements who, as per the finding in that they never took part in the inquiry, only some charge something they took part, correct? Now they were unhappy with the reinstatement. They came and demanding a re-inquiry.
Yes, sir.
And re-inquiry, I mean preliminaries, okay, fine. Now you ordered for like suspend in the meanwhile.
Meanwhile,
So whether
meanwhile.
that's permissible or not, whether is a committee has the power to review, it's your decision.
This is not reviewing.
Then
It may looks like from the representation and the complaint, but now if you look by section 6, it's very clear. And also the complaint, because these are subsequent, these are not referring to the previous complaint they have submitted.
I've not seen one. The thing is that
27 September 2024, this is a subsequent complaint which is reflected in the suspension order
where's
also.
the 27 September 24.
This is with my lord miscase.
It's with the miscase that will explain that the charges are clear.
This is well reflected in order. My miscase 222, my lord.
Yes. Whereas annexure?
Annexure, not yours, no.
Yes.
Oh, yes.
This is at page, my lord. The translation is at page 19, my lord. Page 19. May I read it?
Yes.
27 September 24. The objection.
Why was this not noted down in the?
It is reflected, my lord.
In the order of the
as
in the order of the district council. Why
reflected.
It's already reflected.
Clearly mentioned.
This complaint is reflected 27 September. Where is it referred to?
Can you
It's
see
not
para
referred-
number 2? I just read it.
Or 24th.
Yes.
No,
But
24th
this
September is
27
27 is the date that they had submitted after the hearing. Just 3 days after the hearing.
Okay.
It was heard. They were allowed
No.
to give their written argument, so they have given that. 27 September 2024.
Or this is first after the matter is taken up again, then they file a fresh complaint.
No, not a fresh complaint.
See, base complaint is received. The matter was heard on 24th September, during which the parties were directed to submit written arguments. So this is a written argument, or what is it?
Written argument.
This
27.
one. Where is the written argument?
27.
Page 19.
That is
Mr.
with them.
Sen.
Yes.
Yes, my lord.
Please try to help the court.
Yes.
See, from the order of reading, the 2nd December, based on a para 2, kindly see, based on a complaint petitions as received, the matter was heard on 24th September 2024, in which both the parties are directed to submit the written arguments in 10 days. Consequent arguments to submit according to 27 September. That means, but you see, these are the charges. This is not an argument. That means after the matter was taken up, then the charges were made by the.
My lord, here I will just point out one thing, your lordships. My lord, point out that relevant part, my lord, which say, my lord, district council is competent to make alternative arrangement in case of loss of confidence. My lord, I am heavily relying
No,
on.
you come on that. No, but no, I'm looking at the sequence of events.
Lordship,
The
I
sequence of events that, yes. Second, you refer 24th September is taken up. Where's the complaint petition? So only the 3 complaint petitions regarding for initiation of inquiry. Then in the written argument, which you said an argument, you have brought these fresh charges again.
And these has been duly taken into consideration by the district council.
That is where we are concerned about. See, what we're looking here is only the procedure which is adopted, whether it's above board. That's all. That's the only thing.
My humble submission will be if your lordship comes to the relevant paragraph of the statutes. It simply say, my lord, if there is a loss of confidence leading to deadlock. Now, these are the best person to understand, my lord, the authority to understand is the district council. Now, all these things are there, and these 5 lindos, my lord, I can say confidently I am representing, my lord. We have lost total confidence on this matter. Now, my lord, out of 10, my lord, if 5 loses confidence, my lord, what is the situation, my lord?
See, again, Mr. Sen, please look at the sequence of events.
Lordship.
That's the only thing.
Lordship. So, my humble submission here, your lordships, only because, my lord, some preliminary hearing was concluded on 25, and because a written argument is to come thereafter, and a fresh complaint came on 27 September 24, that will not debar, my lord, considering the language used, if your lordship look into the statute. But this is purely an interim arrangement. This is not final. This is purely an interim arrangement, my lord, if there is a deadlock. Now, my lord, what is a deadlock, my lord? They are the best authority to understand. And they have referred to this complaint. And if your lordship look into this complaint, my lord, there have a series of events, my lords. Provision.
Yes.
19, I think.
19.
This is the emergency provision, your lordship. Your lordship, the very heading is a 19, my lord, if I can read, my lord. Emergency provision in case of administrative deadlock.
Where reading?
Paragraph is, my lord, section 19 of the Act. Lordship has got it?
Yes.
Well, I'll just read it. Lordship will see the heading. Section 19, emergency provision in case of administrative deadlock. Notwithstanding anything contained in this Act, if at any time it is found that a chief of any elaka cannot carry on his duties and function due to absence of his darbar, either on account of vacancies in the post of the mintris, or of recognized member of such darbar, or on account of lack of cooperation or confidence as between the chief and his darbar, thereby creating a deadlock in administration of the elaka, the executive committee of the district council, after due consideration and declaration made of the deadlock in the administration, may temporarily take over the administration of such an elaka and appoint for the purpose of running the administration of such an elaka an administrative officer, and further constitute a committee considering of 4 to 6 members to assist the administrative officer in running the affairs of the elaka. And such administrative officer and the committee shall function and exercise all the powers and functions.
Where does it say about inquiry?
My lord?
Where does it say about inquiry?
No, it doesn't speak about inquiry.
Okay.
It doesn't speak about inquiry. My humble submission, going by this statute, my lord, in case of a deadlock, my lord, an inquiry is not required.
Fine. So
inquiry is not required at law.
Leaving the, just leave the situation aside. Okay. Now, what is this case sitting on its particular facts and circumstances of the case?
Lordship.
There was a complaint
against
the petitioner.
Lordship.
2 charges were there.
Lordship.
On a basis of 2 charges, an inquiry was gone into.
Lordship.
He was found, he was absolved of those charges.
Lordship.
District Council reinstated him.
Lordship.
Right. Now, you come back.
Lordship.
After he's reinstated, he did not take part in the proceedings also.
Lordship.
Some other people took part. And then I think from the records we saw that inquiry asked for the materials from you, not listed as nothing was forthcoming. Then he was absolved, he was reinstated. Now, after reinstatement, you come again with no fresh complaints, only that the inquiry was faulty and demanding a reinitiation of the inquiry. Now that, okay, fine. Those are 3 letters, fine, reinitiation. Now, what did the council do? It's okay, fine. We will look into the matter again. So, on 24th of September, they called both of you. They said, okay, fine. These are the complaints. File your written arguments. Now, before that, there's no other complaint apart from the initial complaint inquiry. Nothing is on record to show that the fresh complaint on fresh set of charges. Nothing. Now, on 27th September, you submitted, it's not an argument, a summary of charges again, which are fresh. Now, taking cognizance of that, they have suspended him again. Now, see the order procedure. Now, when the inquiry asks file written arguments on whatever materials are there, now you come forward and bring a fresh set of charges.
No, my lord, here, that's why my lord, lordship will look into the scheme of that.
So now you look and see, now what he's saying is that, notwithstanding anything else,
yeah, my lord, technically
the procedure,
yes,
supreme is wrong.
Yes,
you know that by which he's been suspended again,
lordship,
is wrong, and so what is important is that is the deadlock in the administration, and so he should go.
Yes.
That's
no,
all.
not go, my lord. I'll say suspension, my lord.
I mean, should go from the post.
Yes,
time being
yes,
or
exactly,
whatever.
my lord. If he's not
And
enjoying
his
the
case
majority,
is that, look, it's double jeopardy now.
Lordship.
He's already been charged once, inquiry gone into, he's absolved, he's been reinstated, you come again, reinitiate inquiry, then that matter is heard, on arguments, you give other charges, and that's the thing. So what prevents him from drawing up fresh proceedings then on a fresh set of charges?
my lord, my humble submission
If
here, my
these
lord.
can be taken as be
My
fresh
lord,
charges.
this is the emergency provision, my lord. Here, my lord, this is not a final inquiry. This is a purely a stopgap arrangements, my lord. Other things will follow, my lord. Obviously has to follow. Once a, my lord, detailed inquiry is initiated, obviously the copy of the complaint and other thing. But at this stage, my lord will appreciate that element of democracy, my lord, here. The confidence of the majority,
Let him
my
take a
lord.
flow test.
My lord, confidence of, but that cannot be a matter of, my lord, my humble submission.
You let him take a flow test with
My
the
lord,
electors.
that cannot
Lordship,
be.
this is a tie situation, Lordship.
No, no,
when you
tie-
will go
that's
to the
fine.
flow test,
That's fine.
Majority.
Lordship, there's a clearly procedural lapses on parts of the respondents, Lordship. I'll show you, Lordship.
No, my lord,
There was
let me finish. He can, I'll just finish, my lord. I'll refer to the statute.
Okay, let's hear Mr. Sen now, yes.
My lord. Now, if your lordship.
Yours is squarely on the ground that he has lost of confidence. So, notwithstanding any charges are there,
my lord,
he should not sit in the chair.
My lord. Now, lordship will, my lord, here, my lord, first, my lord, I'll refer to few relevant provision of the statutes. Now, my lord, 9, if your lordship look into 9, my lord, this speaks about removal and suspension. 9.
Yes.
6. Wait, 6.
It'll be like
9.
Even
9, my lord.
Wait.
Now, my lord, 9 deals with removal. The headman may be removed from the office or suspended by the Darbar. In your opinion, my lord, these are the misconduct. 4, 5, wait, 6.
This is for headman.
Sorry, man.
This is not headman, he's a Sardar.
Removal and suspension of the chief. The chief may be removed from his office and suspended by the executive in its opinion. My lord, these are the list given, my lord. Provided that every such case shall be placed before the council in the next section. Provided further that no chief shall be removed from the office or punished with suspension unless he is given an opportunity. That I fully understand, my lord. Here the suspension, my lord, an opportunity for misconduct. This happened. Now, there are two kinds of suspension, my lord, contemplated. One, suspension, my lord, for certain charges, and another suspension, my lord, under the emergency provision. Now, that suspension, my lord, stems from, my lord, no confidence. Clearly getting lack of, my lord, emergency provision, article, section 19. Now, your lordship, I now take, my lord, again, my lord, at the cost of repetition, 219. The emergency provisions. Now, my lord, the opening, very important opening line, notwithstanding anything contained in this act, if at any time, my lord, that means, my lord, the requirement, my lord, for suspension, giving an opportunity and other thing is not contemplated here. But even then, my lord, district council is fair, my lord, some kind of notices, they sought for a written argument, my lord.
Okay, yes, okay.
They sought some kind of written argument, my lord, good enough, fair enough on their part. They are not under obligations. So, my lord, once the facts come before the district council, my lord, the executive committee.
Where is the finding that the district council is satisfied that a situation exists that
my lord, that order, if I can, my lord, that order they have not even challenged, your lordship. I have annexed with my miss case, your lordship, at page 29, my lord. This is not even under challenge because this notification is based on
2nd December 24.
Yes, my lord. This was not even challenged, and this formal notification was based on
your
this.
challenge is second.
Yes, no.
No copy was supplied to me. In fact, a copy has been supplied to the private respondents. That's why they have annexed it. I'm the person in grief, lordship.
2nd December 24.
I have been placed under suspension. The suspension order has not been supplied to me, but to the private respondents.
Till now, you not got suspension order.
No, lordship.
My lord, if I can
challenge this in substance.
Lordship, I file an affidavit. Bring on record.
My lord, the matter came up for consideration before the executive committee.
Yes.
Petition filed by such and such Sardar of Nongpur Sardarship, alleging that the Sardar had lost the confidence. This is a vital consideration before the executive committee of the electors and was unable to carry the smooth functioning of the election. Based on the complaint petition received, the matter was heard on 24th September, during which both the parties were directed to submit their written argument. Consequent upon written argument were submitted by the complainants on 27th February 24 and 4th October 24, which the Sardar submitted his written argument on 3rd October 2024. Lordship will see, my lord. He has replied to all those things. 3rd October 2024. Upon examination of the materials on record, the following observations are made. Sri Same was reinstated as Sardar of Nongpo Sardarship by notification dated. However, it has come evident from the numerous petition and representation by the Lindos Sardarship that the Sardar has failed to gain the confidence of the electors. This is the vital consideration, my lord. This is what is provided in the emergency clause. The lack of confidence has created a deadlock in the administration in the Nongpo Sardarship, thereby impeding the smooth functioning and affecting the interest of justice. Then other thing followed. So only consideration, my lord.
Where the written this is exercise of powers under section 19.
Exactly, my lord.
Where's that?
My lord.
Where's that order? It said that therefore an exercise of powers section 19 to answer deadlock.
That follows, your lordship. That follows. This has to be under 19.
We have to read. We expect the court to read.
No. Appointment of an administrator is only in 19. They have appointed an administrator. That is only under 19 emergency clause. So what my submission, my lord, these other things are immaterial here, your lordship. It is not a suspension under 6. Under 6, I understand. Give an opportunity, preliminary inquiry and other things. So for this suspension, my lord, due to that law, that depend on the satisfaction, my lord, of the executive committee. And I am standing here representing 5 Lindos. Now, admittedly, there are 10 electors. If the 5 is not cooperating, my lord, that amounts to loss of confidence. Now, he cannot even come and say that the remaining 5 is supporting.
So, we are ready to face trust. What of confidence?
Section 19, Lordship, if there's a dreadlock in the administration, Lordship, apart from 10 members, there are Longsan Mansan also, Lordship.
Whatever it is, are you prepared to seek vote of confidence?
Before that, Lordship, kindly see to the show cause notice issued by District Council.
No, first, yes or no?
Lordship, I'll come to that, Lordship.
No, first, yes or no?
But
yes or
as
no?
on date,
Whether you enjoy the confidence.
As on date, I have 5.
Enjoy the confidence.
I have 5.
You'll have no hesitation saying yes.
Yeah, time frame
I have
may be
5.
fixed in that case.
Lordship, can they just jump? They have 5. I have 5, Lordship. Where's the lack of confidence, Lordship? There's no question of lack of confidence.
Loss of majority, my lord.
Lordship, I may correct the respondents. There are 6 charges framed against me in the first inquiry. Lordship, kindly come to page 41. Lordship.
Before we continue, Mr. any deadlock, any
difficult one. Both sides are very
adamant.
Because as per the writ petitioner, he says that he had no problem when it was being used as a footpath. Now the expansion was done without his consent. So he's hurt by that. And then it would appear that he has also been under tremendous pressure from the villagers. So to that effect, I think some orders should be passed so that he should not be...
Then we'll hear that. We will post it again. Thought on item number 19. Attempt was the petitioners and respondent headmen have appeared before this court in person. This court has inquired from the parties as to whether an amicable resolution can be arrived at, as it affects public interest as well as private interests. The counsels for the parties, counsel parties also have, in their own capacity, tried to work out a solution. But, however, it appears that the same will be possible. As an out-of-court settlement seems not feasible. It's the matter for the orders on.
And another thing, let the state also be made a party, because if the state is willing to pay compensation, perhaps the issue can be
let the matter appear after 1 week. Then we'll pass orders on that day. Yes.
My lord, next week I would be...
After 2 weeks.
After 2 weeks, yes. It's expected that till next day the parties will maintain peace and harmony. You tell them that. The court has observed that there should not be any, Yes. Unfortunate, but even then you can't. It happens really, but because why the court called? I don't see. Once the situation, suppose court pass order in favor of them also, then at the ground level they still be, subjected to a lot of harassment. So
Question
in order
is,
to avoid that, yes.
Lordship, is like they were not consulted. They were
No,
not
we understand.
consulted.
We understand it perfectly.
And plus, they ostracized them from the village. Just
No, that's all. See, might is not right. You know, like they say. Does that mean like though there's a saying that no? Suppose one person in the village is accused of doing witchcraft. Doesn't mean that the majority of it say yes. You know, like practicing witchcraft means that's right. Doesn't mean that the majority doesn't mean that it's right. That is why court looking at that. That's the main issue. That means majority doesn't mean right. But it doesn't mean like we want to use your land for our road. You can go and we don't care about what you feel since we need your land. That doesn't mean the rights of those people are there. Like you think that person practicing witchcraft, his rights are there. You can't just say the majority says he's practicing witchcraft. You condemn for that. That's the thing.
I will see.
Yes.
Now, my lord,
Yes.
other aspect
Who was submitting just now? Mr. Nongpur was submitting.
No, my lord, I have not completed. I just completed. I won't take much. Now, my lord, the other part is.
Why you not completed? You completed.
No, I have not, my lord. The other part is the first inquiry. Lordship has one thing in the mind, and my learned friend is projecting a case that we are reopening the issues.
Yes.
Now, if your lordship,
you have certified a court that even apart that emergency provision, it is not a case of
yes, my lord.
witch hunt.
So far, your lordship, no confidence is concerned, my lord. One is no confidence, my lord, confidence of the court, and other is of the electors. Now, these issues somehow, though framed in that inquiry, so far, my lord, the confidence of the elector, that was not touched. That was never decided. If I can take my lord to the inquiry reports.
That's in your.
It is annexed by the entire additional affidavit.
In this case, 218, no, by district council.
Their additional affidavit.
Additional.
Additional affidavit?
Yes, my lord. Additional affidavit filed.
Bring on record inquiry report.
Yes, my lord.
Filed by the council.
Filed by the district council.
Yes. Yes.
My lord. Now, if you can take my lords to page 12.
Yes.
My lord. If you can see, the suspended Siddhar, charge number 6, Siddharship also has lost the confidence of Sanjung Ki Nong Shinsha Red Nong Po Siddharship, as well as page 12.
Okay.
Page 12, as well as Court CM Nangshai Pildun. The suspended Siddhar, my lord, these are the observations. Nongpo Siddharships denied the above charges and stated that the so-called Sanjung Ki Nong Shinsha Red is a busy body illegally formed in the year 2020 by vested interest with a sole malafide intention to remove him as a Sirdar. That the said body is not recognized or a registered body before any competent authority as in fact an alien to Nongpo Sirdarship. As such, the complaint filed by such and such is without any basis and cannot be taken into consideration in the present inquiry. In view thereof, the allegation that he has lost the confidence in Sanjung Ki Nong Shinsha is immaterial, factually incorrect, and without any basis. He further stated that as per the customary practice prevailing in Nongpo Sirdarship, the eligible electors to elect the Siddhars are 3 Mantris and 7 Lindo. This is his contention, there is 10. The Mantri shall belong to the clan of such and such. Insofar as the Mantris are concerned, he stated that he still has the confidence of the Mantri. In fact, the Mantri, by latter dated, has submitted a clarification to the executive member in charge Alaka, Autonomous District Council Shillong, showing their support. Him, as regards the eligible electors, Lindo, these are the 7, my lord. He further stated that the Lindo of the raid, Lindo, have withdrawn their objection against his removal and that they still have the confidence and support him as Siddhar. Insofar as the Lindo of Raid Nongpo Raid are concerned, the aforesaid Lindos do not have any sanad as per the Act of 1950. In view thereof, even on majority, he still has the confidence of the Darbar. And he further stated that, as regards the allegation that he has lost the confidence of Shah's claim, the same is factually incorrect and false. The Darbar court said by resolution dated such and such has unanimously resolved that the clan members still have the confidence in him to continue as the Siddhar. Pursuant thereto, the President and Secretary of the courts, by letter such and such, has requested the Chief Executive Member, East Hasils Autonomous District Council, Shillong, to withdraw, revoke the suspension order and to reinstate him as Siddhar of such and such. Furthermore, the opposite party stated signatories in letter dated are only 16 in number, which does not in any manner constitute the Darbar Plenum such and such. On perusal of the documents available in record, it is observed that by resolution dated such and such of the Darbar Kursim Dangshai annexed to the Shokos filed by Sri, and on deposition by way of affidavit by OP 9 and 10, the Darbar Kursim Dangshai expressed their confidence, the Sardar. The statement of OP 9 and 10 also corroborated with C such and such, dated such and such, is a testimony of the confidence by the court. It is well observed that the suspended Sardar of Nongpo Sardarship, same Nongchai, has not lost the confidence of the court of as alleged by the complainants in the still extending support. There is no evidence of proof charged that the complainants neither contested nor filed any document. In the light of the above, it is my Lord January. Now, my Lord, here what I am to, so far, my Lord, the court, they have come to a finding. The court has the confidence, he has not lost. But what about now, my Lord, the electors? There is no finding. So there is no question of reopening. And second thing, my Lord, today I may have confidence. It does not mean that tomorrow also I may lose the confidence. This is purely a democratic process, Your Lordship. Once there is a loss of confidence, my Lord, and what he is saying, reopening, matter of confidence, this has been decided. That was never decided. So far the electors are concerned, my Lord. He also requests, my Lord, to enjoy the confidence.
Given enough opportunity,
Lordship.
They didn't participate in proceedings. Lordship. It's not a question of, they were not given an opportunity to contest whatever. He did not.
No, my Lord, it's not that we have not. What we, so far this is concerned, my Lord, first round of inquiry is concerned, my Lord, we made a formal prayer to them that please formulate the charges. No charges were formulated.
By who?
They are two part of the grievance by the district council. We said formulate the frame charges on the basis of our complaint. There were two parts. One is, my Lord, frame the charges. Without framing the charges, you should not have decided the inquiry, taken a decision. And secondly, my Lord, the fresh happenings. What I am saying, what is in your Lordship's mind, the 27 after that preliminary hearing. My submission, this is an emergency clause, my Lords. No such preliminary things are required. It is a case of loss of confidence. 5 lindos are before, my Lords. What he is saying, tied, my Lord. That is a loss of confidence, my Lord. If half of the members are not supporting, my Lord, on record, half of them are not with him. Now, how can he function without a Darbar? So, looking into the language of 19, my Lord, is very clear and categorical, my Lord. This is a decision, my Lord, for the interest of administration of Alaka is vested with the district council. And they have deliberated, they have took into consideration.
Is it your 5 or their 5?
My Lord.
The other 5 supporting him, the other 5 against.
My Lord, that is it not a loss of confidence, my Lord? Tie is a loss of confidence.
You see, Mr. Sen, the courts are not convinced because it's not a question of the matter being examined fully. It was examined before, enough opportunity is given to everybody. And then again you come around again after not succeeding, after being stated, again you come, and then again you bring the same loss of confidence when you already given enough opportunity to demonstrate that before the inquiry officer.
My Lord, as I say, my Lord, there is a matter of loss of confidence. So far, the matter of loss of my humble submission, matter of loss of confidence cannot be subject of judicial review. Well, even, my Lord, the legislature, Prime Minister, suppose the Prime Minister is tomorrow tied, he'll have to go, my Lord. Have to go, my Lord. He cannot say this, we are tied in the voting, so I have a right to go. No, my Lord. He has to have a majority, either a simple, absolute, whatever it may be, has to have. Admittedly, here he has lost, my Lord, and this cannot be a matter of subject of judicial review.
So suppose, okay, fine. What's the procedure, parliamentary procedure? Suppose you don't have any confidence for the government. Then you move a no confidence motion.
Why vote?
So then let him face a no confidence motion.
Here, my the things are more clear. 5 Lindo electors are before my Lord, before the court.
The horse, okay, whatever has happened.
We are before the court.
Not forget everything that's happened. The procedure, everything, forget everything happened.
Lordship.
We are looking at, okay, purely on to balance equities.
Lordship.
Or maybe to public interest.
Lordship.
So we say, okay, fine, let him face the vote of confidence.
Lordship, my lord, here nothing is more clearer because five
No,
Indo
let
electors
him
are
feel the
before
vote
your
confidence.
lordship. We have lost the confidence.
If he succeeds the vote confidence, he continues.
My humble submission, my lord, lordship is satisfied. I'm representing five Indo electors who have lost.
You agree with the idea?
I would have to seek instruction in that case. Lordship, the thing is that there's an inquiry officer, which this is just a temporary measure. This is not nothing final. Just to ensure, because why we have seen there's a majority which have already lost confidence. Now being cautious, and now earlier also, because this reinstatement happened in the beginning of 2024. Now that complaint happened 2023, way before that also. Now because of that, 3 years has gone. So now the administration has been affected. So for that reason, we had gone to that section 19. Deadlock is there. The administrative officer, in fact, the day that he had moved that writ petition, or was the day that the administrative was on the way to take charge. But when he came to know about the order, we had to stop him. Inquiry officer is already.
Yes. What do we have to say?
So let him a time frame may be kept, and then we will have
vote of confidence.
Yes.
That
I have to seek instruction.
Before I part your lordship, one small suggestion, if I can, my lord. As I said, my lord, this is an emergency provision, my lord, making an alternative arrangement. Now, lordship, right now, without any Dadwar, Elaka is suffering, my lord.
Yes.
Now, what your lordship can do, my lord, vacate this order, let the interim arrangement come in place. In the meantime, whatever your lordship, that deadlock and other things they may appear, can be resolved. But right now, my lord, the administration is suffering, my lord. Lordship
Yes,
can understand.
yes.
Without Dadwar.
Yes.
Lordship, firstly, Lordship, there are 6 charges in the first.
Yes, where is that?
Page 41.
In the writ petition.
In the writ petition, page 41.
Page
41.
These are framed by the inquiry
by
officer.
the district council. By the district council,
okay.
Lordship. 6 charges were framed, Lordship.
Yes. Yes.
And Lordship has clearly read charge number 6 and the finding of the inquiry officer.
Yes.
Charge number 6 says he has lost confidence.
Yes.
And as well as from the Kur Imnongshai clan, Lordship. That is very important, Lordship, the clan. Because the clan recommends the name of the person as to who has to be appointed as the CM, Lordship. Then he's put into then he's elected by the electors. Lordship, these charges, I faced these charges. Private respondents never appeared. Lordship, kindly see from the inquiry report, which your Lordship have read it. They
Yes.
never participated. So the onus is on them, your Lordship. The onus is on them to prove these charges against me. But they failed to appear.
Now, but you see one thing, Mr. Nompure, the fact remains notwithstanding anything else. Again, keep on repeating this word. Now, 5 link doors have come.
5 link doors.
Right.
Lordship.
So, how do you answer that?
Lordship, because the impugn order says deadlock administration, Lordship.
So, how do you say that? I mean, how do you answer that? How do you respond to that?
Lordship,
Is it a fact that you've lost the confidence of 5 electors?
It's not a fact, Lordship.
Is it a fact?
It's not a fact. Lordship, these are only allegations to oust the petitioner.
So 5 people have signed the Mrs. application for vacating, correct?
Lordship.
They all required as filing this application, 5 of them.
5
correct?
of them are on
And if you see the 10 electors only.
10 electors.
So lost confidence will be confined with the electors, or maybe it's a Darbar Pulun.
Lordship, the Darbar Pulun also has a say, Lordship, in this case. So far as the confidence is concerned, Lordship. Now that resolution was brought before the inquiry officer. They never challenged that, Lordship. They never came forward to oppose that. Till date, Lordship, I still have the confidence of the Darbar.
So on hindsight, they've come again with to reinitiate inquiry.
Lordship, exactly, Lordship. Kindly come to the show cause notice which the district council has issued to me, Lordship. Page 61. Page 61.
Okay. Very interesting case.
Page 61, Lordship.
Usually courts don't interfere with suspension of district council, but this is a very exceptional case. Yes.
Page 61, Lordship. This is a show cause notice issued to me. I may be allowed to read. With reference to the subject cited above, find enclosed herewith letter dated 30/4/2024, 22/5/2024 for information and knowledge, and you are to be directed to submit a show cause with regard to this matter on or before 31/5/2024. Lordship, page 63, which my learned friend has already showed to this court. These are the letters which have been enclosed to the show cause notice. And the subject matter is reinitiation of the inquiry proceedings, Lordship. Page 65 also, page 67 also, Lordship. The subject matter is reinitiation, Lordship. So the basic grievance is that they were not granted ample opportunity before the inquiry officer, and that's why they're demanding for a reinitiation of this same inquiry. And page 69, Lordship. Based on these three complaints, I was directed to show cause, Lordship. Now I filed my show cause, Lordship. The show cause was not considered by the District Council and they had passed the impugn order, Lordship.
Where is show cause? You've seen that, I don't know, where is that?
Lordship, the order is at page
17, next year 17.
Next year 17 is the my show cause reply, Lordship. Then after this, they never considered my show cause and they have placed me under suspension. Right order dated 2nd December 2024. So basically the first grievance is against that they were not granted opportunity before the inquiry officer. So that's why they had demanded for reinitiation of the same inquiry. The impugn order is at page 12 of the affidavit filed by them, by the District Council. I should have read and have seen it. And Lordship, the private respondent has referred to the complaint dated 27 September 2024. Lordship is...
1 second. Yes.
And Lordship, they have suspended me, right, order dated 2nd December 2024. But it's at page 8 of Miss Case 218. That is the order.
So page 8 is the order. Where's the notification?
Notification will be at page 79 of my writ petition.
Okay. Next day.
The next day, sir.
Yeah.
Then Lordship, the suspension order is at page 8 of the affidavit filed by the Miss Case, Lordship.
Yes.
Lordship, the second paragraph, Lordship.
Yes.
It's clearly that the matter was heard on 24th, Lordship.
That's what the court's observing.
Lordship.
Yeah.
So the 27 complaint which the private respondent has submitted, Lordship, that is afterthought, Lordship.
Now he's functioning.
I'm functioning.
With full confidence.
Lordship. I'll come to
he says full confidence.
I'll come to the Darbar, Lordship. Including me.
So, yes.
So the matter was heard on 24th, Lordship, and parties were requested to file the written argument. So basically, Lordship, after hearing the matter, Lordship, the 27 September 24 comes into the file of the District Council. And the substance of that letter, Lordship, the complaint,
yes,
is no confidence. So basically, the private respondents are trying to address the grievance against their lack of opportunity before the inquiry officer, and by these complaints they are trying to oust the petitioner on the same set of allegations, Lordship, and the same sets of charges which the District Council has framed against me in the earlier proceedings.
So which page was the charges that was on page?
Page, Lordship,
of
page
your 61.
41, Lordship.
41, yes.
41, Lordship.
That's important. You have to give some authorities on double jeopardy.
Lordship, I do not have that with me. Not with me. Not with me right now, Lordship.
This is a concept of law.
Lordship.
Then?
I'll place that, Lordship. Page 40, 41,
Yes, page
42 is the
41,
charges.
Yes.
So the district council has basically reviewed the entire proceedings and reviewed the suspension order, in which the reinstatement order, whereby the petitioner has already been reinstated, absolved from all his charges, Lordship. And Lordship, the substance
Report is in the affidavit of
filed by the district council, Lordship.
So this council is not there.
District council
Your
had filed-
affidavit. In your additional affidavit, correct?
That is the suspension order, Lordship.
No, the inquiry report.
Inquiry report is in the affidavit filed by the district council, Lordship. In this case, number 218, Lordship. Lordship, the arguments that the inquiry officer.
One second, just that. Affidavit 218. The inquiry report. 20 is not there.
Lordship, the affidavit dated 2nd April 25.
No, filed what? 222. Huh? 222 then. Petition power. Yes.
Lordship has the inquiry report.
Yes.
Lordship, the arguments advanced is that the inquiry officer has not dwelled into the aspect of no confidence. That is incorrect, because at page 14, Lordship, the inquiry officer has clearly given her finding that the petitioner has not lost the confidence. So from the substances of the arguments, Lordship, the private respondents are aggrieved by the first inquiry proceedings and the reinstatement order, for which the private respondents has other recourses to challenge the same, Lordship. Until date, they have not done that, Lordship.
Yes, you bring some authority on double jeopardy.
Lordship.
On same charges.
Lordship, if I be allowed to submit, Lordship. One more thing, Your the 27 September 2024, can you have a look at that, Lordship? 27 September, which is reflecting the order of suspension. That is the written submission submitted by them. On the basis of this submission made in this letter, because these are all fresh, Lordship. Can you see? Can you have a look?
So we've seen that it's all fresh. Regarding after the statement, he went and
After the matter was heard,
terminated another person. He went and did this and that. He became a law unto himself.
Exactly, and he has done a lot of things. This is very clear. Taking
After
this
the
into
matter was
consideration,
heard.
he was suspended.
You bring authorities tomorrow.
Lordship.
Yes.
Can it be on Tuesday, Lordship? Tuesday, Lordship.
Okay, Tuesday.
Yes, regarding the working in the functioning in the Elaka matter, I should know. I will be biased, obviously. My learned friend can apply. District council can
This is the matter
there is no
over here on Tuesday. We will reserve it on Tuesday, or we'll pass judgment Tuesday, sir.
33.
Obliged, Lordship. Lordship, the interim order will continue.
Yes, interim order continue for the orders.
Highly obliged.
Yes, Mr. Dubey.
But I'm sorry, my lord, I had promised the lordship that I'll be physically appear.
Yes.
But somehow I had come up for the division bench over here.
So more, he had more, what do you call it, promising cases there than here, yes.
No, blood. I am representing the Airport Authority of India over here. Blood. The matter was regarding that lease to the private respondent, my lord. Some matters were there, my lord. I had to be here. That's what the difficulty was.
Yes. Yes. We take at 2 o'clock.
No, sometime. But
Yes. Mr. Dubey.
My lord.
The other side are all ready. When can you do the matter?
My lord, if I can pray for a date in, my lord, sometime mid of April, my lord.
Lord, can it be on 23rd minute? I have another matter with your lordship on 23rd minute.
23rd April. Yes,
My
I
lord,
request the parties.
I'll do it.
Yes.
But I am making a request, but there is an interim order that needs to be continued.
So interim order should continue. Yeah, but you're taking advantage now of the interim order. No. Okay, yes.
No, it's not that, Lord. Well, my client is getting no benefit out of it, but still, since
Right.
the lordship is hearing in the
Right. Right. Yes.
deeply aware.
34.
MSA Karshi. Yes, Mr. Majah. What's the matter about?
Suspension order, Your Lordship.
Lordship, the conducting counsel has some.
Mr. Barasaji.
No, my lords. Mrs. Sheller.
Mr.
NG Sheller.
NG Sheller.
He has some?
Personal difficulties. She had to leave. My lords, I may appraise the matter and the facts.
Who the conducting counsel? You are or she is?
Mrs. Sheller.
Maybe next week. Maybe next week, Lordship.
Next, after 1 week.
Hurry up.
36.
Yes. Ready with the matter?
Yes, Your Lordship.
Ready? We'll have it at 2 o'clock then.
If that
Yes.
litigation, Your Lordship,
Why?
this matter may be taken up on next week.
Where are you going?
I have some personal difficulty.
You need to take a nap.
No.
Then?
Next week, then, if that.
Why? What difficulty are you having?
I have.
You can finish in 10 minutes.
Yes, Your Lordship.
Yes.
15 minutes.
And you'll take how much? 5 minutes?
5 minutes I'll do it. Yes, 5 minutes will do.
Okay, yes. Start, yes.
Your Lordship, in this case, the petitioner is a retired government servant who attained his superannuation in the year 2019, Your Lordship. And he is yet to receive his gratuity, Your Lordship, even after a lapse of 5 to 6 years. And no doubt, Your Lordship, he received several letters to submit from the department to submit the birth certificate and the joint photographs for his family pension, Your Lordship. But Your Lordship, that is with regards to the family pension, and ours is gratuity, Your Lordship, which is a one-time payment, Your Lordship. And Your Lordship, we have filed a representation in our petition, Your Lordship, page 28, annexure 8, asking the department to release our gratuity, Your Lordship, but then no positive outcome, Your Lordship.
Which department?
It's sericulture, Your Lordship. Sericulture department.
What did he say? Why did they deny you gratuity? It's your right.
Yeah, actually, Your Lordship, the respondent, the state, like they have submitted in their affidavit, Your Lordship. Kindly see their affidavit, Your Lordship. Page 3. They have clearly mentioned in the AG office, Your Lordship, affidavit. Respondent number 5. Page 3, paragraph.
Of the AG?
Yes, Your Lordship.
That is.
Page 3, Your Lordship. They have clearly mentioned the cause for delay in payment of gratuity, Your Lordship, is because details of family members were not mentioned in the in Form 17 of the family pension. But Your Lordship, Form 17 is significant only to the family pension, Your Lordship, and not to the gratuity, which is an earnest benefit, Your Lordship. And Form 17 will take effect only after the death of the government servant.
He's
And
alive.
yes, Your Lord. And in our case, the petitioner is very much alive to receive it himself, Your Lordship. And
What does the state said?
Your Lordship.
Your Lordship, in my affidavit at page 6, annexure
We
1.
take the same stand, Your Lordship, Form 17.
What's response 17?
Your Lordship, we just wanted to determine whether he's a bachelor or not, Your Lordship. We just want if he can produce a bachelor certificate, Your Lordship.
That will come in the family pension, Your Lordship.
Yes,
Ours is
because-
only gratuity, Your Lordship.
They have asked the bachelor certificate from our department, but the department cannot give a bachelor certificate.
What the bachelor certificate has to do with payment of gratuity?
Yes.
Because this is this is what the AG office required. So we have already processed. We have submitted the.
Where's Mr. Karmo Plank?
He's on leave, Your Lordship.
This is a matter on Tuesday.
Your
We'll dispose it of. Tell him to be here.
Yes, Lordship.
This is absurd. Gratuity, you're right. Yes. Just a matter on Tuesday as a fixed matter. You just tell Mr. Yes, you tell him to be here. Oh, you're prepared on the matter.
I've prepared, but I'll take instruction.
No, because yes, take instruction because we'll dispose it off on Tuesday.
38.
Hello, Blitz.
Lordship, and come after 2 weeks, Lordship. The chanda is not available today, Lordship.
Yes.
It's a covered matters, Lordship.
No, it said there's a matter pending for Supreme Court.
Lordship, but most of the orders has been passed from this court.
The matter is
Waiting for warrant
still
officer.
pending, my lord.
Just the matter of 2 weeks is on the request of Mr. Eman Nopur.
39.
Same orders, Lordship. Same orders.
33.